Hope you are all keeping well and safe. It is nice to meet all of you. My name is Ruth Pineda, and I have been working with KA and GPS as a senior consultant. Our session for today will be approximately 1 hour. We will have a presentation to be followed by the Q&A in the latter part. Everyone except for the presenter will be put on mute mode. So if you have questions or clarifications, please leave a message in the chat notification, or you can also raise raise your hand option. You can click it, which you can find in the bottom screen. All your questions and clarifications will be answered by the speaker in the Q&A part, which will be moderated by Mr. Prasad Bonde. Before we proceed, I would like to give a brief introduction of our company, Qatari Auditors and Accountants, or commonly known as KAA. KAA has been established and operating for more than 27 years now. It has been established in the year 1992, providing management and financial consulting services, which includes audit, accounting, VAT, and company registration services. KAA is operating in 2 offices, one which is located in Khalid bin Al Walid in the Emirate of Dubai, and Bank Street, Rolla in the Emirate of Sharjah. Our associate office, Global Business Services, DMCC, which is established in the year 2010 and located in Jumeirah Lakes Towers, Dubai, specializes in the formation of global entities such as trusts and foundations in the UAE and worldwide. I would also like to invite Mr. Prasad Bonde to give us a more introduction and the services we provide to our company. Mr. Prasad, can you please join us?
Yes, thank you, Ruth, and I welcome everyone to this webinar. Thank you for joining us. My name is Prasad Bonde, and I have been associated with Qatari Auditors for the last 13 years. I am working as a senior audit manager here. I'd just like you to inform regarding our services we offer at Qatari Auditors and Global Business Services. So as Ruth said that we have been established, Qatari Auditors and Accountants has been established in the year 1992. We have 3 offices in the UAE. We are also a member firm of the IAPA, and we are also approved on the majority of the banks, free zones, and UAE authorities. Our core services in Qatari Auditors and Accountants include audit, accounting, system designs and implementation, computerization of your systems, management and financial management consultancy services. We also undertake project feasibility studies, project reports. We do cost audit and cost analysis as well, business restructuring, and valuation of business. We have a sister concern called Global Business Services DMCC, which was established in 2010. We are registered agents for all UAE offshores, approved agents for UAE free zones. Our services in Global Business Services include company formation, onshore and offshore, company formation in major offshore jurisdictions, company management and administration services, corporate restructuring, branch registration of foreign corporation, establishment of trust and foundations, trustship, provision of foundation councils, corporate tax planning, accounting, as well as ESR services, economic substance regulation services. We are also providing financial consultancy services, including CFO services. We are also providing service for inheritance planning and services relating to wills, drafting of wills. So these are the basic services which Qatari Auditors and Accountants and Global Business Services offer. Now I ask Ruth to take the session forward.
Thank you, Mr. Prasad. We will now proceed with the presentation. Our session for today will be presented by Mr. Vipul Kothari. Mr. Vipul Kothari is the founder and head of KAA and GBS. He has the unique distinction of passing the Chartered Accountancy at the age of 21 from the Institute of Chartered Accountants in India. He then went on to receive gold medal awards from the BK School of Business Management and MBA Finance. In this session, Mr. Vipul will give us an overview and guidance on how to protect your assets through inheritance planning, which will include will registrations in the UAE. Ladies and gentlemen, please let us welcome Mr. Vipul Kothari.
Thank you, Ruth, for your words of introduction. Good evening, good afternoon, everyone. Welcome to this session on inheritance planning and will registration. Thank you all for joining in today for this particular session. I hope my sound is okay. I'm audible. If not, Ruth or Prasad, please let me know. So before we begin, I would just like to highlight a couple of things. Always there are concerns in UAE that what happens on death of a person, what would happen to my assets and the investments, the companies that I am primarily involved in or I have a stake in, and the management that I am involved in the companies that I have stake in. So this is a very critical thing, and there are a lot of, I would say, doubts about these issues, and especially because many people do not have a proper inheritance plan or a will in place, and in that case, it becomes very tricky, especially because it's an Islamic country with Sharia law in place. And that's why it's not a common law where generally the assets goes to the family member as per the will generally or as per the wishes of the beneficiary. And then because of this, it's very much essential that you need to have a proper inheritance plan and of course a will in place. In today's session, over next 35 or 30 to 40 minutes, I would cover in brief about what are the options for inheritance planning and of course securing your assets for your loved ones. And then we'll have a question answers. So as Ruth said, if any of you have questions, you can put it in either chat or else you can raise hand also, and at the end of the session we'll unmute you so you can ask your question. Now, what happens is if you do not have proper inheritance plan in place, and generally what happens, everyone has bank accounts, whether it's individual or joint account. Many people feel that I have a joint bank account with a spouse. So, to that extent, I'm protected, or I have assets owned jointly with the spouse. So to that extent, let's say spouse can manage my assets. Then of course, there would be companies' bank accounts, personal vehicles, mobile. Now, UAE, one thing is very clear, it's not a common law country, it's a civil law country. So generally what you generally expect in common law country, where joint account options are there, where joint ownership of assets are there. Here, joint ownership of assets or accounts are there, but what happens is whenever a person dies or passes away, normally the bank accounts are frozen. So it's not either or survivor holding of assets. It is jointly till both the individuals are alive. As soon as one person is no more, all the assets which are jointly owned technically gets frozen, and then you have to go through the legal process to get an order from the court to pass on the assets of the deceased to the beneficiary. Many a times the other issues are the beneficiary or the person might have loans or borrowings. And what happens in that case, other assets, even if they are not mortgaged, could be in jeopardy. Because if there is a legal process, personal assets could come under scanner and could be used to settle the loans liabilities if it goes to the court. Many a times the information is not available to the family about what investments and assets a person has, and documents are not available. And if this is the case, then you are not able to even recover those assets. Family visa is another big concern, because generally the residency visa for foreigners of the spouse and kids is generally under the husband. And in case of death of husband, that family visa becomes an issue. And of course, in order to ensure that all the assets are transferred to the beneficiary, you have to go through a long process, getting order from the court and then transferring assets with respective authorities. And you need funds and cash for that. So what happens if the family does not have money? So these are all the issues. So what generally we suggest is, Now, this is just one chart, not to scare anyone, but as per Sharia, if a person does not have a will in place, the distribution goes as per normally Sharia. Now, in Sharia, it depends, the distribution depends on how many sons are there, how many daughters are there, whether father or mother is alive, brothers are alive, sisters are alive or not. So it depends on various factors, and distribution percentages could change. These are two examples. The first one is, if you assume that there's deceased had one son, one daughter, wife, father, mother who are alive, then the percentage distribution, as you can see, is 36.11, which goes to son, daughter is 18, wife gets 12 and a half, father, mother gets 16.67 each. That's how the asset or estate would be distributed. If you assume that the deceased had only one daughter, wife, father, mother, then the percentage changes. Daughter gets 50%, wife still gets 12 and a half only, and father, mother, they get 20 and 16% respectively. So this becomes very tricky, especially when deceased does not have proper inheritance plan or a will in place. And that's why it is very essential that for UAE assets, inheritance plan has to be in place. The best option that we generally suggest, and which is from a very long-term perspective, very effective, is a structure where you have foundation and a company below the foundation to be used as inheritance planning. This is one example of the structure where you have foundation at the top. Now in the foundation, as you can see from this chart, the founder or the person who holds the asset, generally who is called either a settlor, he would put all his assets in the foundation. And obviously then he would appoint council members to manage the affairs of the foundation, and he would have guardian also who would be able to monitor what council members are doing and have veto power. And then obviously he will appoint the beneficiaries or recipients. So as and when the distributions have to happen, it would go to the beneficiaries. Now, generally below a foundation, you would have an offshore holding company. Now, reason we have mentioned UAE is because if you wish to hold assets in UAE, especially real estate in UAE, then you need to have a UAE entity to hold that. So primarily the offshore holding company would hold all the assets, whether it is bank account, whether it is real estate, any asset portfolios, investment, or even operating companies would be all owned under the offshore holding company. So at the foundation level is where the inheritance plan is being put in place, because at the foundation level, the settlor who owns the assets defines that, you know, who the beneficiaries are, what their percentages would be, and what distributions would be made. And he would continue to manage the foundation till he is there. He would continue to have certain control over the foundation and the assets of the foundation. And after he is no more, the council members which he has appointed would carry out. And there is a role of guardian also in place. Now, guardian is generally one of the very trusted person that he can appoint, who would oversee and supervise the work that council members are doing. Council members are technical terms like a board of directors or governing member of the foundation. So they will manage the affairs of foundation, and to supervise the work that council members are doing and to veto that in case they are not doing certain things properly, guardian would have the powers and rights to override those decisions that council member takes. So foundation primarily would be holding all the assets via the offshore holding company. So what happens in this case is the founder would retain control at the foundation level by having appointed guardian, which could be himself, and also he could be director of the offshore holding company. So he would then manage all the assets which are underlying in the offshore holding company. That's how he would retain control till he is alive. After he is no more, the guardian would take decisions or council members would take decision, and appoint people to manage the offshore holding company. So that's how the structure is generally done. Another structure, because many people feel that, foundation we do not wish to have. Why should we have that? In that case, you could remove the foundation again and directly have a holding company. But let me tell you in this, the disadvantage of this is when you do not have a foundation, you're not able to define the beneficiaries, the nominees, and who would basically get the assets once the death of the founder happens. In that case, there would be a will which is registered in UAE, which would then decide on the shareholding of offshore company should go to which beneficiaries in what proportion. So this is another way if someone does not want to have the foundation at the top. Ideal structure would be having a foundation. Now, what are the key benefits of this particular structure? The biggest benefit and advantage of this is that all the assets are held under one umbrella. So it's easy to manage. Whoever has the powers to manage the affairs of foundation and or the holding company will be able to manage the entire structure and the entire assets which are underlying. In case of death of any of the beneficiaries, any of the founder, or you do not need to actually transfer individual assets to the beneficiaries. Only the shares are transferred in the offshore holding company. If it is only offshore holding company, or if it is foundation, the beneficiaries directly get the benefit as are defined in the foundation charter. Management and ownership gets segregated, because you may wish that, okay, beneficiaries should not get involved in or interfere in the management of the foundation or the holding company. You could structure it when you do the foundation charter, and you could have independent directors or independent council members or some other trusted people as the council members to manage that. In case of death of, let's say, an individual and the assets are held under that individual's name, all the assets are frozen and you cannot manage any of the assets. Everything gets blocked. What do you do in the interim if it takes 6 months, 1 year, or more than that to transfer the assets to beneficiary? Till that time, assets cannot be operated, funds are blocked. Whereas in case of a structure, if you have foundation or holding company, at least the operation and management of the company continues. Only the ownership of the company could be in question if there is no foundation. If there is a foundation, that question also would not arise. And of course, the biggest benefit of having a foundation is that you can specify that who the beneficiaries would be and how much would be their benefit out of it, and you can control the distribution. So it's not necessary that you need to transfer the benefits every year or distribute the assets or the earnings from those assets into the beneficiaries. You can define if you have a foundation in place. So what are the advantages of foundation? The biggest advantage that foundation has is that it is a distinct legal personality, unlike a trust. Many of you would have heard the concept of a trust. Now, trust is merely an arrangement between the trustee and the settlor. So technically, there is no trust which exists in legal parlance. It is only an understanding between the trustee and the settlor. And trustee says that, okay, I'll manage your assets, and they create an internal document which is called ABC Trust, and they hold the assets on behalf of that ABC Trust for benefit of the beneficiaries. Whereas in case of foundation, it's a separate entity per se. Tomorrow, those trustees do not exist. Your foundation and the assets under that foundation do not go into jeopardy. You are not reliant on those trustees. You have a right then to change the trustees, and you can have other council members managing the affairs. The biggest advantage is you are separating the liability. What happens is, and this is again, there is one more aspect, that you control the assets, but tomorrow, because you have transferred the assets to the foundation without any liabilities, your assets are protected. So in future also, if there is a potential liability against the settlor or the founder, the foundation assets cannot be attached unless there are cases where someone has deliberately, with malified intention, created a foundation and transferred the asset just to avoid the liability. But as on the date of creating a foundation, if no liability exists and founder knows that no, he has not pledged or there is no liability created against assets, then those assets would be secured. Even if some liability arises because of his some other transactions or other assets, some liability arises, at least these assets will be secured. Foundation will continue even after the founders are no more. So it becomes even as a tax planning tool, because in many countries you would have seen that you have huge amount of estate duty which has to be paid when the assets are transferred from the founder or the settlor to his or her beneficiaries. And that estate duty sometimes, comes in huge percentage, could be 30-40% in some cases. So foundation could be used as a potential tax planning tool also legally, which is permitted. So asset continues to remain in the name of a foundation, and the beneficiaries only get benefit as and when the distributions happen. So technically there is no transfer of asset happening. So you are not liable for any estate duty. Also, you are not liable for any capital gains tax or transfer fees, because if you transfer assets, normally there are sometimes, in countries where there are taxes, you would have capital gains tax, or you could also have the transfer fees in case of certain other assets. So foundation that way is quite a good tool and vehicle to hold your assets for the estate planning. Of course, there are costs associated with maintaining such a structure, because annually there are fees that you need to pay and there are charges which are applicable. So in case where you have sometimes, assets which are sizable amount, foundation in this structure would work really very well. And in UAE also, because UAE till now was not recognizing foundation, but it has started permitting now foundations to be set up, and that can be set up in DIFC, which is a common law jurisdiction, ADGM, which is again a common law jurisdiction, and Ras Al Khaimah, which has RAC Foundation, RAC ICC Foundation, wherein again dispute resolution, you can select for dispute resolution a common law jurisdiction. Then as we said that under a foundation, you have a holding company, because normally assets are not held directly in the foundation. It is always advisable that even if you have a foundation, create an holding company underneath the foundation, because foundation is not as such a corporate entity. So at some places in terms of compliance, due diligence, there could be challenges. So it's always advisable to have an holding company, which is an offshore company, and that holds all the underlying assets, whether it's bank account, whether it's investments, whether it's your properties or even operating companies. Now, advantage of having a UAE offshore company, which could be RAC ICC or even Jebel Ali offshore, is 100% foreign ownership is permitted. So foundation can own that 100%. Of course, UAE does not have any corporate or personal taxes. So that is out of, there are no taxes payable on that. That RAC ICC or JABZA can also conduct international businesses. It can hold investments and assets. It can own properties in Dubai also or in UAE, and it can own bank accounts. And for dispute resolution, it generally allows that you can select DIFC or ADGM for commercial disputes. And again, management can be professional managers, and the shareholder need not get involved if he does not wish to get involved in the management of that. So that becomes an easy structure to manage. Sorry, 1 minute. Yeah. The next topic is on the will registration. This was on the foundation and the structure to hold your assets. But many a times, many people have concern that it becomes one when you create a foundation and the holding company. Technically, the assets are not in your name. You are only owning the shares in the offshore company, or you might be a beneficiary in the foundation. So many a times there is hesitation that why should I transfer my assets to a foundation and I do not have control over maybe those things, which is not the case, but still many people have that hesitation. And of course, another concern many would have is that we do not have control over the assets. And there are cost aspects also, because if you have to maintain a foundation and an offshore company, there are annual renewal fees and charges which are payable. Of course, now with so many options available, those are not very expensive. But if your property or asset values are probably less than few million, it may not be worthwhile doing that structure, because then that elaborate structure would cost you probably little in percentage terms, if you see, more than what ideally you may wish to have. However, if portfolio size is more than 10 million, I think it makes real worthwhile sense in having it under the structure for the ease of operation. And especially the benefit is, on death, you do not have to do transfer of any of the assets. Automatically, the foundation will take care, because the beneficiaries will just change in that case. However, many people do not wish to do. In that case, obviously, will registration is must. And even if someone has that foundation and or only offshore holding company structure holding assets, you still better do a will, which you register it in UAE. Now, many people say that, okay, I am a citizen of XYZ country, and I have registered will in my own country, my country, and or I have registered in consulate of my country. Whether that would be valid, acceptable to UAE courts or not. Chances are that would not be acceptable. And it's a very long process, because if your will is registered overseas in or only in the consulate of your country, then first thing you need to do is apply for probate in your home country. That would take time. There might be objections. Once you get a probate, an order from the court, then you need to get it translated, attested, legal translation, present that thing in the UAE court, and then it is up to the UAE court to take a view whether they would recognize that foreign court order for transfer of assets or not. So that's a very long process. So not just cumbersome, but even there are doubts whether actually you would be able to enforce the wishes of the will writing person, whether the assets gets transferred to the beneficiaries he desires. And till such time, uncertainty of distribution of asset and the asset and the money gets blocked. So the best way for people who, and especially the foreigners who are staying in UAE, is to register a will in UAE courts. In UAE, earlier there was no option of registering a will, but last few years, in fact, almost 10 years, they have been registering will. Dubai court was the first one to start registering will. Then DIFC came in with wills and probate registry, and then Abu Dhabi court started registering the will. And Dubai court, then also Dubai government actually promulgated a law which specified that now any foreigner holding assets, and if they are non-Muslims, they can register will in UAE to transfer all their assets to the beneficiaries, and that will would be considered for distribution of their asset and for giving an order by the court to transfer the assets to the beneficiary. So it's always advisable that have a will registered in UAE in either of these three jurisdictions, wherever that one would look at. Now, what are the criteria for will registration? The first thing is, the most important is, the person should not be a Muslim or should not have been a Muslim at any point in time. However, Dubai court does allow Muslims also, or local courts, I would say, not just Dubai court, Dubai and Abu Dhabi court, or for that matter, any other court would allow registering a will for Muslims, but only 1/3 of assets can be covered under that, because under Sharia law, Muslim cannot transfer or give more than 1/3 of his assets by way of a will. The remaining distribution has to happen through, as per the Sharia. Another requirement is person has to be over 21 years of age, because in UAE, below 21 is considered as a minor. Obviously, person would have assets within UAE, and for minor child, if someone has minor child which are below 21, then obviously they would need to appoint guardians. And these children should be habitually resident in UAE. As far as will is concerned, it's not very difficult. It can be a self-drafted will also. Courts do not say that you need to have a professional drafting a will. However, it is recommended, so that because it's a lifelong thing, once you make a will, it's going to last forever, and it's going to be used after the death of the individual. So it's better that have it drafted professionally so that they can take care of all the nuances. So it's not that it would be in a very typical legal language that one would understand. Generally, it's a very simple language that is used, but it has to be very clear and unambiguous. So it has to be very clearly specified. There should be no ambiguity, because if there is an ambiguity, there would be issues at the time of transfer of assets and distribution. And one has to think of all the possible scenarios and appoint who would be the executor, trustees, guardian, beneficiaries, as well as what would be the share. And register this with appropriate authority, again, either of DIFC, ADGM, DIFC, Abu Dhabi Court and Dubai Court. Let's understand various roles which are applicable or relevant to drafting of a will. Testator is generally a person who is making a will for himself, because he would lay down that, okay, these are my assets and these are my wishes, that I wish to appoint so and so as executor, trustee, guardian, beneficiaries. So testator is that person who is preparing the will or whose will is being prepared. Executor is a very important role, because when the person dies, the order from the court has to be obtained, the relevant court. And obviously one person has to present all the documents and necessary evidence in the court and liaise with the court. Now, who is that person? Executor is the person who would carry out all the process of transfer of asset, including submitting for probate, obtaining an order from the court, getting all the assets transferred to the beneficiary. So it's a very important role. And it's always advisable that have more than one executor, because today, if one person is no more, then obviously the second person will act as executor. If second is no more, the third person can act as an executor. And another thing which is required and advisable is that executor should ideally be residing at the place or a location where you are registering the will, because if he is not based in UAE and he is based in India or any other country, it would be difficult for him to carry out the role of an executor, because he would need to travel to UAE to do a lot of things which he may not be able to do. So always have executor who are based locally in the country where your assets are. Trustees are the people who would take care of the assets in the interim if there are minors, if there are beneficiaries who are minor, or if there are beneficiaries who probably could have potential, let's say, disability in future, who would manage their assets. Then you would have trustee managing their assets. So you appoint, again, you have multiple trustees. Guardian, you would need to appoint in cases where you have minor child below age of 21. Now there are two guardians that you would have to look at. One could be interim guardian, which could be someone in UAE who would take care immediately on a temporary basis. And there could be a permanent guardian, which could be based in your home country, because maybe after death of a person, children are not able to stay in UAE because of visa or any other issues. They have to go back to their home country. Then who would be permanent guardian? So it's always required to specify in this manner, interim and permanent. And of course, the most important part is beneficiary. Beneficiary are normally family members, but could be anyone else that person desires. Always in beneficiary also, it's always better that specify what either assets are to be granted or what percentage of share of asset the person has to get. And in that also, it's always advisable to have multiple beneficiaries. So for example, if husband is preparing, he could, let's say, make wife as the sole beneficiary 100%. In case wife is not there, it could go to children in equal proportion. If children are not there, maybe it could go to children of those child. And if they are not there, it could go to some other family member. Or even if someone wants to specify in the ultimate, as we call it, as a disaster clause, if none of them are alive, it could go to some charity. So, specify the beneficiary considering all the eventualities. And of course, you need to have witness, which is required for DIFC will. So you have to take 2 witnesses for witnessing that, yes, you are the person who has signed in their presence this particular will. Other important matters: estate, you need to specify what assets you wish to cover under the will. Generally, we suggest that let it be generic will. So you just specify all the assets based, let's say, in UAE. And because if you specify a particular asset saying property X, and tomorrow property X may not be there, and you might have bought property Y, or you specify a particular bank account, today it is there, tomorrow it may not be there, then you might have to go for change of will. Instead of that, go for a generic will rather than specifying assets. And even the distribution, let it be more generic rather than saying that, okay, I give property X to my wife and property Y to my child. Rather than that, probably it could be, you can say percentage that, okay, 100% goes to wife, and then if she is not there, goes to 50-50 to kids, 2 kids. Or you could just say percentage directly to each of them if you wish to do it in that manner. Also, you need to specify what would be powers of executor and trustee. Normally, they need to be granted all the powers to manage the asset and the estate, because they are the ones who will have to ensure that assets are, they obtain order from the court and then transfer the assets. And in the interim, if any of the beneficiaries are minor, then they'll have to manage it till they become major. So they'll have to have all the powers to manage those. Of course, they cannot use that money for their own benefit. They will have to use it for the benefit of the beneficiaries only. Then this one, bequeath, we have already covered, and the cremation wish, if someone wants to add that, that could be added. Now let's look at the 3 options that we have in UAE: the DIFC, Dubai court, and Abu Dhabi court. So in each of this, I'm not going to go into individual in detail, but in each of this, there are specific applicable laws. Of course, for Abu Dhabi court, there is no specific law under which they are registering a will. It just goes under the civil transactions law, under which they register by way of a separate decree. Dubai has issued a Dubai law number 15 of 2017 regarding execution of non-Muslim will. So there's a separate law. And of course, DIFC, it has a wills and probate rules and regulations, which are based on common law. So the advantage of DIFC is it is a common law jurisdiction, which is more probably known to us, and it's followed, let's say, in UK or many of the countries. So we are more accustomed to it. Assets covered generally, as far as Abu Dhabi and Dubai court is concerned, you can cover UAE assets, entire UAE wide assets, whether it's in any of the emirate. As far as DIFC is concerned, it permits now. Earlier, it used to permit only Dubai, then it included Dubai and Ras Al Khaimah, then UAE, and now, of course, global assets also. However, as far as execution of the will pertaining to global assets is concerned, it is subject to that respective country where you present. Let's say, for example, you have a bank account in Singapore, you hold assets over there, and you register a DIFC will covering the global assets. And anything happens to the settler, the testator, the will of Dubai DIFC will have to be presented in Singapore, and it then depends on Singapore authorities whether they would accept the UAE registered will or not. But DIFC allows you can cover global assets. And in DIFC, you can have different type of will, full will, property or will, guardianship, business owner or financial asset. However, I think what is to be seen here is, I think full will is something which has to be done. Now, as far as cost of registration is concerned, these are the cost of the DIFC or Dubai court or Abu Dhabi court. There is quite a bit of difference because DIFC is 10,000 for a single will, and if it's a mirror will, so husband and wife both preparing the will, it will be 15,000 compared to a lower amount in Dubai court and Abu Dhabi. But having said that, what happens is, if you look at DIFC being a local, common law jurisdiction, all the proceedings happen in English. So in future, whenever the eventuality happens and person dies, you have to present the will to the court, respective court, for a grant of probate. Now in DIFC, because everything happens in English, there is no compulsion that you need to appoint a lawyer. The executor can himself present and get the process done. Whereas in case of Dubai court and Abu Dhabi court, the proceedings would be all in Arabic. So in normal scenario, one would need to appoint a Arabic PRO or a law firm to take care of that matter. And at that stage, you would end up paying substantially higher amount to the lawyer to carry out all that process of execution. Whereas in case of DIFC, you may not have to do that. So in my view, technically, DIFC registration of will would be more ideal considering the future, because in future, when the execution has to be done and the male member is not around, you cannot expect the female member to, or wife, your spouse or children, to undergo the hassle of going through the lawyer and taking that pain and trouble. So it's always advisable, though in the initial stage you spend considerably higher for registration of DIFC will, but in the future, definitely when the eventuality arises, I think your overall cost would be on the lower side. So that's on the comparison. Now, just very few important tips before I close and we'll open for question answers is, as I said in the beginning, there are joint accounts in UAE, bank accounts, but it's not either or survivor concept. So even if it's husband and wife both owning, jointly holding the bank account, in case of death of any one of them, the account is frozen and you have to then go through the legal process to unfreeze and recover the money. Also, there is no nomination facility in UAE. Generally in other countries, especially where common law is there, most of the places you have an option that every asset you can nominate a nominee who can hold the asset on behalf of beneficiary. Here you cannot do that. So it's always advisable that, see, when the eventuality happens and death of a person happens, money could be there in the bank account, joint bank account, but bank account is frozen. They cannot access, the spouse or the children cannot access it. So though money is there, they can't use it. What do they do for their living, for the expenses, for the court fees, for transfer of assets? So it's always advisable that have a separate bank account for spouse in her individual name, so that anything happens to husband, spouse has a bank account where they have enough funds to sustain for 6 months to 1 year till the time all this matter gets resolved. And in that spouse bank account, you could give power of attorney to the husband. So wife could give power of attorney. So husband can manage and operate, but if he is no more, at least the bank account of spouse does not get affected or blocked. This is another interesting and very big issue is dependent visa, because if spouse is holding a dependent visa, spouse visa, and not an independent visa may be cancelled, though UAE and Dubai had announced that they would permit them to stay for a certain period of time. So we have to see that, how that is being implemented. So but still advisable that have an independent visa for spouse. And of course, guardian, if they are not appointed, court would appoint a guardian, and it's not necessary that they would appoint wife only as the guardian, they could appoint someone else also. As I said, have adequate funds so that spouse is able to sustain for at least 1 year and take care of the legal aspects or legal costs. Last slide, have a list of complete assets and liabilities, and which should be updated and easily accessible to the family members as and when it's required, with the contact person for such assets and liabilities so that they are able to communicate and contact them. List of important documents and their expiry, because these are very necessary and essential to have. One thing which many miss out is that, see, will you register it's operational only after death of a person, and when the death certificate is issued. What happens if a person is either incapacitated or disabled, or is not able to, let's say, work, and he is probably, because of, let's say, in COVID situation, he was out of country for a long time and he could not manage? What happens in such cases? In that case, it's always better that have a power of attorney, a general power of attorney, give it to your spouse member or other family member, so that they are able to manage your assets. They can at least carry on with the operations of bank account or the assets. Of course, real estate they cannot sell, because for real estate you need specific power of attorney mentioning the property details. So for every property, then you might need to specify. But if you make a general power of attorney, at least they can manage those assets and manage the bank account. And of course, register the will, keep copies with executor and spouse so that it's easily accessible. They know exactly what to do and who are the beneficiaries. And of course, also keep copies of marriage certificates for spouse as well as birth certificate of children. Generally, if will is there, these things will not be required. But if some people do not have will registered, then these documents are very essential to prove the relationship. So that's it from my side. Thank you very much. Thank you all for your patient listening. And I'll request now Prasad to take over and see if there are questions, and I would be glad to answer them. Thank you.
Prasad, I think your mic is on.
Sorry. Thank you, Vipul sir, for such an informative session. I hope everybody is benefited with that. Now we'll move to the question answer session. As informed earlier, you can ask your questions by typing in the chat box, or you can also raise your hand so I can unmute you and then you can ask your question. So we'll start with the questions. First, we'll start with certain questions we received along with the registrations. So the first question is from Mr. Kirit Shah. So he says that, do I need a will if I don't have any property in the UAE and I do not have any sizable cash in UAE?
Yeah, I mean, see, if you are able to manage without that and your asset transfer or distribution, you don't feel there would be any issues since you do not have any major assets, then will may not be necessary. But again, you have to think from long-term perspective. Today, you do not hold assets. Maybe in future, if you really have some assets or properties in UAE, then at that point in time, you should, in fact, I would suggest get it done earlier prior to your acquiring of assets. So you have to be quite vigilant on that, because you never know when you actually get assets over here or when you buy properties. So it's advisable to have at least one will registered, whether it's Dubai court or DIFC.
Thank you, sir. One more question we have. My will was made in 2013 and registered with Ministry of Justice in the UAE. Is it still valid?
Yes, this is a big, I think, doubt many people have. Let me clarify. Ministry of Justice never registered a will. What used to happen is that you used to register a will with the consulate and then get it translated, and then Ministry of Justice would attest that translation. So there was no registration as such. Registration has to happen in the courts. So technically those will are like you have registered either in overseas country or in overseas consulate. So as I said in first slide initially, that if you have an overseas will, you have to go through the process of obtaining probate from your country of origin and get it translated, attested, submit to local courts, and you have to then go through that long process. So that is uncertain and time and cost involved in that. So it's always advisable, get a will registered in UAE.
The next question we have from Mr. Kamda. He says that I believe that there are wills attested at DIFC and wills that are attested in local courts. It would be useful to know if they carry same authority. Are offshore companies and FZD subject to UAE Sharia law?
On the will registered with DIFC and Dubai court, there are different authorities. DIFC is registered under DIFC court and DIFC wills and probate registry, and which has its own set of rules and regulations. Dubai court registers under the Dubai, notary registers under the Dubai court, and that follows the Dubai laws or the federal law. So there is a difference, common law versus the federal or the civil law. So there is a difference, and I explained in the comparison what could be the challenges if you have a Dubai court will vis-a-vis the DIFC. Personally, of course, I'm not against any of the jurisdiction, whether it's Dubai court or Abu Dhabi court. My only concern is if you have registered in local courts, you have to probably have a lawyer at the time of execution, Arabic speaking PRO or a lawyer, law firm, to handle that. Whereas in DIFC, because it's an English and common law system, it's relatively easy and you may not need a lawyer. So in the end, you might end up saving on the lawyer cost, and which are substantially high in many cases I have gone through. Those are quite high compared to the savings that you might have at this point in time in terms of your registration fees. As far as, what was the second question?
Are offshore companies and FZD subject to UAE Sharia law?
Yeah, I mean, see, these are all registered under the UAE regulations. So it all gets covered under the UAE federal regulations or the local regulations, which are based on the civil law. So what happens in case of death of a shareholder? The shareholder's ownership of the shares will be transferred based on the local court if you do not have a will, and that would be subject to Sharia law for sure.
Okay, we have next question. What law applies if a Muslim married to a Hindu wife? Does the Sharia law supersede even in the event there is a will?
See, a Muslim, basically husband will be owning all the assets, and I'm assuming he would be Muslim, he is Muslim. So if he is a Muslim, he cannot register a will. Even if he registers will in local court, he can only grant 1/3 of his estate. And remaining 2/3 will be as per Sharia. So practically, if person has a will registered somewhere or the other, technically it's incorrect. He cannot grant benefit or transfer of asset for entire estate if he is a Muslim.
And do beneficiaries also have to be residents?
Not necessary. Beneficiaries can be residing anywhere. They need not be UAE residents. They could be based anywhere.
Then we have certain questions from Mr. Kamdar again. Are offshore trusts useful as a tool to hold shares in offshore companies or FZDs, or are they not relevant? Is there any equivalent to trust in the UAE?
Offshore trusts, see, that was the vehicle used earlier. Nowadays, the challenge in offshore trust is one, UAE does not recognize trusts. And if you hold offshore trust as the parent entity, issue comes in the local bank accounts. There would be challenge with the local authorities. Today, if you have an offshore trust and you say, go to Ras Al Khaimah or Free Zone Authority or any local authority that I want offshore this trust to be the shareholder, they would not accept it. They do not recognize. That's why this foundation that I mentioned is a recognized entity in UAE, because these are being formed under the UAE regulations by DIFC, ADGM or RAC. So they would be recognized, and that can own the offshore company and the underlying assets. And nowadays, another challenge in having offshore holding company or offshore trust or offshore companies, or by meaning offshore, I would say, overseas, let's say BVI, Seychelles, or any such jurisdiction which are outside UAE. The biggest challenge nowadays is attestation of documents, because any document of an overseas company, if you have to submit to the authority here, you need to get it attested in UAE consulate in those respective countries, and the costs are quite high. And many a times the local authorities, especially if it is a trust and if it's a discretionary trust, what happens in case of a discretionary trust, the beneficiaries are not defined. They are at the discretion of the trustees. Now, if beneficiaries are not defined, their percentage of benefit is not defined, whenever the ultimate beneficial owner has to be proved to the bank or to the free zone or the local authority, there is a challenge because there are no defined beneficiaries. So banks would not consider if there is a discretionary trust at the top, unless and until, of course, some comfort can be given to the banks or the authorities that yes, such and such person is the beneficiary and some document can be proven. But it's a very challenging thing. It can happen. I'm not saying that it cannot happen, but it's a very challenging thing if you have an offshore trust, and especially if it's a discretionary trust where the beneficiaries are not defined.
One more question. What happens to assets held overseas by the offshore companies? Are they subject to Sharia law?
Assets, now two things in this. One is, I'm assuming if it's an offshore company, a UAE offshore company holding overseas assets, the UAE offshore company shares would be subject to Sharia provided there is no will registered in UAE. If there is a will registered in UAE which covers that offshore company shares also, then technically Sharia goes out, then it does not cover. And if that is not covered under Sharia, then obviously the assets which are held overseas also will not get covered. If it is an overseas company, like a BVI company holding overseas assets, then technically UAE has no jurisdiction over such company or assets.
There's one more question. Do you need to mention property details in the will in detail?
Not necessary. As I mentioned, you can mention if you wish to, but not advisable, for the reason that you might change the property. You might sell the property, you might change the bank account, and then again that will would be useless because then you'll have to go for an amendment of the will. So generally it's advisable that have a generic will where you just mention that all my assets, all my properties, all my bank accounts, XYZ, all these type of assets are covered. So advisable not to, but having said that, if someone wants to and specifically says that, no, I wish to mention this particular property and that should go to my wife only or to my children, such and such son or daughter, they can mention. It's not that they cannot mention. They can do that.
We have one question from Mr. Arvind. On Sharia distribution side, why is father and mother share different in first case with son and versus second case without? I thought each parent.
Sorry to interrupt. Yeah.
So each parent gets. He thought that each parent gets 1/6 share in each case.
Now in Sharia, the distribution is considering some different proportions. So it depends on who all beneficiaries are there, and based on that percentage gets calculated. So it's not that standard daughter would get. Generally, they say that if it's son will get, let's say, X percentage, daughter will get half of that. And then 12.5 goes to, let's say, wife, and then remaining gets distributed between father and mother. In other cases, if number of beneficiaries are more or less, the distribution can undergo a change because it's based on a different concept altogether. There are actually certain websites where you can check, where you can punch in the details saying that, okay, there is one son, one son, two daughters, and, father, mother alive, and a brother. So, and then it will give you the distribution.
One question, what happens to company bank account if one of the partner dies?
This is a very good question and very tricky one because what happens, there's no clarity on this aspect. Technically, ideally, the company is a separate legal entity. So technically, the company should continue operations. Of course, the director would get replaced. But having said that, if that is the only shareholder and director, the bank account could get frozen, or many a times even if that's not the only shareholder and director, the bank account could get frozen. Then you have to approach the court. They issue what they call as a temporary, temporary succession certificate, or they issue a power of attorney to manage the affairs of the deceased by way of one person. They will appoint someone so that company can carry on operations, and that person will then sign on behalf of the deceased, and then the bank account will get reactivated. So this is going to be a very big challenge because I've seen in some cases that it has been blocked, and then you have to go through the process of obtaining an interim order, and then continue with the company operations. And then pending the final order succession, the company continues operation. After that, once the final order comes, then the shares gets transferred and the actual beneficiary comes in.
Is general power of attorney valid after death of the giver of the power?
Not at all. Once the issuer of power of attorney is no more, the power of attorney is technically invalid and cannot be used. Of course, the courts do not automatically, I think, block it, but it cannot be used at all. So should not be used.
If assets are listed in general term, what happens to the asset when they are distributed? Are they sold off and then distributed according to percentage?
No, if assets are specifically mentioned that, okay, property X has to go to wife, then that property X, if it exists at the time of distribution, then property X will go to wife. Property X will get transferred. But if it is mentioned that, let's say, property X has to be distributed in proportion of 25, 25, 50, then that would be transferred between the three beneficiaries. And if there's no agreement to that effect or no specifications in the will itself on a specific asset going to a beneficiary, then it will get distributed in proportion. So it might be sold off. Now see, that all depends on the executor. And that's where the role of executor comes in, because executor's role is to ensure smooth execution of the will, including transfer of assets to the beneficiaries. So when there is a dispute, he is the one who will have to make sure, mediate, and get them to agree. Now, depending on what all the beneficiaries agree, if they say that, okay, I agree that my share, instead of giving me this particular asset, give me this much money or give me shares in another company. So it could happen that way. And eventually, if there is no agreement, yes, then court could appoint someone and just sell the assets and then transfer in percentage what is specified in the will.
Sir, one question from Ms. Arina. She was just asking us to brief on the disadvantage of will against a foundation.
See, will is basically the the settler is just giving his wishes, specifying that these are the beneficiaries. So will would come into operation only on death of a person. When the person dies, then the asset gets transferred, and literally it gets transferred to the beneficiary. Whereas in case of a foundation, what happens, even while the person is alive, he could specify the beneficiaries in the foundation, and the assets could be used for the benefit of those beneficiaries while the settler or the founder is alive. So that's a major advantage that you have. And plus, other than that, as I said, it protects you from claims. Let's say some unforeseen liability arises in future. Today, someone sets a foundation, transfers all the assets, no liabilities are there on his head today. So he has done it with good intentions. Future, he does some business and has huge losses and he has to pay. Now, can his foundation assets be attached? Technically, no. Foundation assets cannot be attached. It basically then is a separate, because it was not done with that intention. And generally in all the jurisdictions, they have certain time limit that if within this period of time after the assets are transferred, if there are no liabilities against it, then technically in future assets cannot be attached. Another advantage of foundation is tax planning. Many a times when you transfer the assets, as I said, estate duty, if you are in a high tax countries, and especially it happens, let's say the parents are over here, the children are based in USA or Canada or some tax countries. Now, if there is no no foundation or such structure in place, what would happen on death of a person? The assets would get transferred to those beneficiaries who are staying in those countries. So in those countries, then whatever income is earned from those assets, they would get taxed. Whereas if it is accruing to a foundation and foundation does not distribute to the beneficiaries, technically, there could be no tax. So, it depends from country to country, but I'm saying it could be as a tax planning tool. So there are various benefits of having a structure in place. And another thing, when you transfer the assets from individual settlor or main person to the beneficiaries, you have to pay transfer fees. Dubai does not have corporate tax or personal tax, so there is no question of capital gains tax. But if Dubai had or UAE had, then there would be capital gains tax. Suppose they hold assets overseas somewhere, and those asset gets transferred. Obviously, there is if it's at a profit, there's a capital gains tax. So there are various distinction and benefits of having a foundation and structure in place.
So one question is, can Muslims register the will? So I think the answer is no.
I had covered, see, in local courts you can, but again, 1/3, not beyond 1/3 you can transfer. And there are restrictions on Muslims registering a will.
From Mr. Kamdar, any disadvantage of a structure with offshore holding company only holding assets with a UAE registered will, and the will would state that the offshore holding company shares are transferred to the foundation on passing of one or both spouse?
Yeah, that also is possible. You could structure it whereby you can specify that in case of death, it goes to XYZ as a beneficiary. So practically, instead of passing to individual beneficiaries, it could go to the structure that probably you have already created. Or in many countries, it is done in that way also, that you have a will and then you specify that, okay, on death, you create a trust and transfer all the assets to the trust or the foundation. So structuring can be done and drafting in that way can be done.
One question from Mr. Siddharth. When the ultimate beneficiary is a foundation, there are difficulties opening a bank account. Is there a solution to it?
Yes, there are challenges for sure. But again, in UAE now, the foundation that you open, generally the beneficiaries are named and you get documents from, generally the biggest disadvantage of trust or foundation is from banking perspective, they wish to know who the beneficiaries are. If it's a discretionary trust, again, you don't have beneficiaries defined, you will have challenges in opening bank account. If you have documents to prove that yes, XYZ are beneficiaries, these are issued by, the documents are issued by the registering authority, then I believe banks should open. Yes, it would take little longer time period than your normal companies or bank account, personal bank accounts. But challenges are there, but it's a one-time challenge and time that it takes. I think going forward, once it is probably more done once, then you don't have a problem.
One question from Ms. Elena. In order to establish a foundation of all my assets, do all the assets need to be located in the UAE?
Not necessary. Foundation, you can have assets based overseas also, but again, problem would be whether overseas country where your assets are, do they recognize foundation and will they register foundation, UAE based foundation as the owner of those assets? And generally what we suggest is, again, foundation directly does not own the assets. Foundation would have an underlying offshore holding company, and that offshore holding company would own the assets, which could be based in UAE or it could be based overseas also. So key thing here to see is that overseas, if you have some properties or assets, do overseas countries, that particular country, does it allow that assets or real estate in that country to be owned by a UAE based, let's say, holding company? You'll have to check on that aspect in that country.
Are there any restrictions on who can be witness or executors under the will? Can a beneficiary be executor or witness?
Beneficiary, generally in UAE, they do allow, especially if it is a family member, like wife or children, they are allowed, but they cannot be witness. Beneficiaries cannot be witness.
Can the founder of the foundation be a beneficiary too?
Founder can be a beneficiary also. Yes, that's possible. And he can be in the governing council also. So there are generally, only guardian and council members. So each country or jurisdiction has different rules. But majority of cases, the founder can exercise control over the foundation council as well as, be a beneficiary in most of the cases. I think it's permitted.
One question from Mr. Gupta. You have mentioned that you can set up a foundation and an offshore company, DIFC, and RAC offshore. Do you have any international jurisdiction for these entities?
International jurisdiction for these entities, I am not able to understand. See, DIFC Foundation and then offshore holding company is RAT. So there's no question of any international jurisdiction coming in here. You could have a foundation registered overseas also. You have Jersey, you have Panama, you have many such countries which do register foundation. So you could register a foundation in those countries also. And you could have then a UAE offshore company for holding your UAE assets. So that also structure is possible.
Can POA be given to a non-resident of UAE?
Possible. Could be given to anyone. Not necessary person has to be a resident of UAE. POA can be given to anyone that the power of attorney issuer wishes to issue to. Yeah. Any more questions?
Yeah, Mr. Kamdar, I think, has one point that one may not want to disclose all assets held by an offshore company holding under ESR regulation.
Pardon, can you repeat that?
One may not want to disclose all assets held by an offshore company holding under ESR regulation.
See, ESR regulation is a different regulation altogether, which primarily does not ask for specific assets to be disclosed, that what assets does it have. Yes, it has to ensure that it has substance. Any holding company has substance. Now, generally, substance requirement for holding companies are very minimal. They generally need to have a registered agent and adequate directors or local people to manage those assets. So you do not specifically disclose assets. So I don't think there is any question of disclosing assets. It's only proving the substance.
One question is what level of details of beneficiaries do we need to mention?
Where in the will? I assume it is in the will. So generally, level of detail would be their name, their see. Ultimately, you have to look at it from the execution perspective. Whenever the eventuality happens, death happens, probate has to be issued. How would court identify a person? That yes, this is the same person. So mention full name, date of birth, passport number. So it gets tied up, because if there are similar name people also, you can still prove it by way of a separate passport and date of birth, generally, that yes, this is the person. And of course, their address, probably residential address.
Is the foundation legal entity subject to ESR?
Foundation, currently it has not come under that purview, but I would assume that because it's a legal entity, ESR covers all sorts of legal entities. The foundation has been actually started just very recently. So I would assume that yes, they would come under ESR, because ESR law is very wide. They say, any licensee which carries out activity. Now activity, if they are doing those 9 activities, it would get covered, even foundation.
And what is the approximate cost of foundation structure?
Foundation structure cost would vary depending on which jurisdiction that you actually go with. You go with maybe DIFC you go with RAC, it would be quite cost effective, would be less than probably, I think, $2,000 odd dollars. If you go with DIFC ADGM, that would be slightly expensive. You could be looking at something around $5,000 to $10,000, depending on, again, who the agent and the who helps you in setting up, because the major part is professional fee part. And if you set up overseas, again, the cost could be anywhere from, I think, $2,000 to $5,000-$6,000. So that's year one. And then annually, you would again end up looking at probably around 50 to 60% of that cost as your annual maintenance cost. And offshore holding companies could be anywhere from 1,500 to, again, $2,500 US.
One last question.
Which, jurisdiction you select.
One last question from Mr. Rishabh. He says that I have mentioned property details in my will, along with the clause that all properties in the future as well are also to be treated in certain manner. Does that cover the issue specifying property details, or it is still better to avoid?
It's okay. There is no problem if you mention specific property, and if that property exists on the date of the will, that property would be distributed as you have desired. And if you have added a clause saying that, okay, all my properties which I buy in future and are there at the time of death will get covered, then definitely that also will get covered. So I don't see that as a challenge. I think there is one question from Mr. Anup before Mr. Rushabh. I think it's for a person holding properties in UAE, which jurisdiction is better, DIFC or Dubai court, or it doesn't have any impact?
Yeah.
So, answer to that is it does not as such have any impact. Only thing is you have to see the process of getting a probate. Again, I would reiterate, DIFC, common law, English versus Dubai court, which is civil law, and Arabic process. So this is only a part of the process and the cost involved in that process. So you have to assess that and then take a call whether DIFC or Dubai court. In my personal view, I would prefer DIFC for the simple reason common law, and because common law gives certainty that assets will be transferred as per the wishes of the beneficiary. And again, English, so that the spouse or the people who are left behind do not have to go through the hassles of getting a probate.
I think that's all. We don't have any further questions.
Okay.
Okay, thank you all for the very informative and interesting questions. If you have further clarifications, please let us know and we will answer them all through email. You can send your email at vipul@vipulqatari.com or info@gbsei.com. You can also reach us at 04-447-1804. Once again, we thank you for joining us today. I hope you enjoyed this webinar and you find it of great value. Our offices are always open to assist you with advisory and financial consultancy needs, such as audit, accounting, company setup, and registrations, will registrations. You can also please check our website at www.gbsei.com and www.qatariauditors.com for the full list of services that we offer. Thank you all and have a great evening.
Thank you everyone for joining in and for quite a few interesting questions. I will be glad to clarify any questions that you may still have uncleared or unanswered. So glad to, please do reach out to us. Thank you very much.